Greetings and welcome to Constitutional Law, Provision for Full Faith and Credit from American Jurisprudence. All right, everyone's arrived. I'm glad the notifications finally got out, and I can get rid of that, and let's get going. Let's see here. Give me a second here, get the chat all dialed up. Get rid of that message there. And please hit the like if you've just come in so we make sure that the algorithm lets everybody else know that we're ready to start. As always, we'll have Black's Law Dictionary 9th edition at our side to make sure we leave no word behind. And with that said, let's get started. We're going to be going over Section 1018 from Constitutional Law of American Jurisprudence, and that's from Section 15 or Chapter 15, Full Faith and Credit. And in general, constitutional provision for full faith and credit. And I believe this is a 2022 update. Yes, May 2022 update. Yeah, here we go. American Jurisprudence, Constitutional Law. And we're towards the end of it, as we've done several episodes of constitutional law, going around to the ones that are more prominent, more commonly experienced for most people, and working our way down that list of priorities. However, this one has preempted some of the other sections because full faith and credit is a foundational part of constitutional law. Let's get started. Okay, the United States Constitution provides that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and that Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. I said, shall be given. So this is a cornerstone too with the way the union is constructed here. The full faith and credit shall be given in each state to the public acts, each state, the records, and judicial proceedings of every other state, and that Congress may, by general laws, prescribe the manner, capital M here, in which such acts, records, proceedings, shall be proved. So the manner, this is how we have them admitted as evidence, the effect thereof. So important thing to catch here. Of course, the way it comes in seems a little strange, but it makes sense as we go on. Okay, the general rule is that things done in one's sovereignty in pursuance of the laws of that sovereignty are regarded as valid and binding everywhere. Think about that. What's the pursuance of laws of one state, sovereignty, etc., are regarded as valid, binding everywhere. Everywhere. Not just other states, but everywhere. A federal statute provides the mode in which the public acts, records, and judicial proceedings of the states are to be authenticated, and further provides that such acts, records, and judicial proceedings, or copies thereof, so authenticated, will have the same full faith and credit in every court within the United States and its territories and possessions, as they have by law or usage in the courts of the state, territory, or possession from which they are taken. So, before I clarify it, let's go on, because American Jurisprudence will be clarifying this. As it always starts out, as even though it seems general, is the section we're on here, they start out with a pretty comprehensive and wordy preamble here. Let's continue though. The doctrine of comity is distinguished from full faith and credit in that the latter is an explicit constitutionally based provision involving relationships only among the states, where comity is based not on a constitutional provision, but on concepts such as harmony, accommodation, policy, and compatibility. And that's footnote 4. But before we go to 4, let's look at this observation. The purpose of the full faith and credit clause is to avoid conflicts between states in adjudicating the same matters. The full faith and credit clause alters the status of the several states as independent foreign sovereignties, each free to ignore obligations created under the laws or by judicial proceedings of the others, and makes them integral parts of a single nation. So this seems a little bit contradictory in a way, but when you look at it like this, it's actually a deeper way of keeping the union from falling apart and fragmenting due to conflicts. The purpose of the full faith and credit clause. Full faith and credit avoids conflicts between states when they're adjudicating the same matters. So the clause alters the status of the several states. This is a clause that alters their status, makes the several states independent foreign sovereignties, each free to ignore obligations created under the laws or by the judicial proceedings of the others, and makes them integral parts of a single nation. So think about that. Each free to ignore obligations created under the laws or judicial proceedings of the others. But as we read before, they're supposed to be given and binding everywhere. So let's continue here and see if we can bring this all together. Recognition and enforcement of foreign judgments under the full faith and credit clause. Authentication of enactments of another state, and that comes under evidence. The full faith and credit clause is one of the provisions incorporated into the Constitution by its framers for the purpose of transforming an aggregation of independent sovereign states into a nation. So, this clause is one of the provisions incorporated into the Constitution, as again we're reviewing constitutional law. The purpose is of transforming an aggregation of independent sovereign states into a nation. And that's as recent as 1998 and 2007. And again, footnote 4 was leave to appeal dismiss. That was 2020 New York. Interesting that that's right here. So this is more the doctrine of comity is distinguished. So this is a good case if you want to find that distinguishing features between comity and full faith and credit. So again, the full faith and credit is an explicit constitutionally based provision involving relationships only among the states, whereas comity is based not on a constitutional provision but on concepts such as harmony, accommodation, policy, and compatibility. So interesting that this case would have that as part of the ruling. Let's continue. We're on to section 1019. Interpretation of full faith and credit clause. The law favors expansive application of the full faith and credit clause in order to fulfill the clause's purpose of ensuring that all states within the federal system recognize each other's official acts, judicial actions, and judgments. And as we read before, the judgments are considered property. The constitutional requirement as to full faith and credit must be interpreted in connection with other provisions of the Constitution. Thus, the full faith and credit clause of Article 4, Section 1 should generally be construed and considered together with Section 1 of the 14th Amendment. That's footnote 3. That's very interesting there because should generally be construed and considered together. Should, operative word here. So let's consider footnote 3 before we go further. 1937, okay. 1935, and that is Hannaran's will. Okay, let's proceed. On the observation, the full faith and credit clause has been construed as not constituting a limitation upon the bankruptcy powers of Congress. However, a statute requiring federal courts give full faith and credit to the acts, records, and judicial proceedings of any state, territory, or possession applies to bankruptcy courts. Interesting there. And absent fraud in the procurement of a default judgment, bankruptcy proceedings may not be used to relitigate issues already resolved in a court of competent jurisdiction. That's an interesting one there too, and that's footnote 5. The doctrine of full faith and credit precludes relitigation in dischargeability proceedings by the bankruptcy court of factual and legal issues actually decided in state court. Wow, so this is interesting here too, that the bankruptcy court factual and legal issues actually decided in the state court would stand according to this. But as always, remember that this broadcast is strictly for the entertainment and educational purpose of this live stream alone, and the rebroadcast of it is not to be used, construed for anything legal, lawful, professional, personal, financial, or tax otherwise. Don't do this at home. Let's proceed. All right, so we finished up the observation here. And we're on to the next section. Section 1020. Statutes and constitutions as public acts for purposes of full faith and credit clause. Interesting that they have to make the distinction, which means we should be aware of this distinction, that statutes and constitutions as public acts for the purposes. So full faith and credit clause would be regarding the statutes and constitutions as public acts. A statute is a public act within the meaning of the U.S. Constitution, Article 4, Section 1 of the Federal Constitution. If a court of one state refuses to enforce a statute of another state in a case in which it ought to do so, and in which the statute gives a right, it thereby denies the full faith and credit demanded by the federal Constitution, because a statute is a public act of another state. Public act. A statute is a public act of another state. A statute which has the effect of refusing to permit actions against residents of the state by a non-resident to enforce a foreign statutory liability assessed under the statutes of another state violates a full faith and credit clause. Moreover, the full faith and credit clause is operative not merely with respect to the public acts of a sister state, but also with respect to the attributes thereof. However, the full faith and credit clause does not require a greater effect to be given to a state statute in other states than is given to it by the courts of the enacting state. So, it does not require greater effect to be given to a state statute in other states than is given to it by the courts of the enacting state. So, you can never have another state which gives, I guess, higher penalty or such when your state already prescribes one. It can't be higher than the one in the state that's the enacting state. That's what I read out of that. But let's go along for the clarity. The duty imposed upon the courts to give full faith and credit to the Constitution of a state as a public act of the state is as obligatory as the similar duty with respect to the judicial proceedings of such a state. So, the duty upon the courts to give the full faith and credit to the constitution of a state as a public act of the state is just the same duty as to respect the judicial proceedings. As we read the introduction, acts and judicial proceedings and judgments. Under the full faith and credit clause, District of Columbia must recognize the status of a foreign receiver as established by foreign law. Wow. And accord that foreign receiver the same rights and privileges against judgment creditors seeking to levy against assets in the District of Columbia, that the district would accord the same kind of receiver if appointed locally in the District of Columbia. Wow. Consumers United Insurance Company versus Smith, 1994 in the D.C. Now that's interesting. Give me one moment here. And the full faith and credit clause requires the state to give full force and effect to the constitution of a sister state. Full force and effect. That's 1951. And we're on to section 1021, statutes and constitutions as public acts for purposes of full faith and credit clause. And before we go to that, let's double check on the chat here. Give it a quick refresh. We have Edward Sawicki says, sadly last time, it'll be the one I have to watch later again, but this looks like it'll be the most interesting and curious topic yet. It is quite curious, I will give you that. Let's proceed. While the full faith and credit clause of the Constitution has been held not to apply to a federal statute, so that a state is not required to enforce a federal statute, the supremacy clause of the Constitution has the effect of making such statutes enforceable. Nevertheless, there is some authority to the effect that neither Congress nor the United States Supreme Court, has power under the full faith and credit clause to take from a state forum the right to decide, according to its own standards, whether a federal statute is a penal law unenforceable within its jurisdiction, since Article 4, Section 1 applies only to sister states. The state may not discriminate against rights arising under federal laws. And that was 1934. So that goes back quite a while. And we're on section 1022, application of full faith and credit clause to particular public acts and statutes. As might be expected, the full faith and credit clause has been invoked, sometimes successfully and sometimes not, with respect to a wide variety of foreign statutes, including, among others, statutes pertaining to adoption of children, alimony, antitrust laws, arbitration, breach of warranty, child custody and support, contracts, corporate liquidations, creation and dissolution of corporations, extradition, evidence, fraud, garnishment, immigration. The list goes on. Insurance, including statutes authorizing direct actions against insurers, and statutes relating to mutual fraternal benefit societies. Mutual fraternal benefit societies. Interest rates and usury, legitimacy of offspring. Marijuana possession. Marriage and divorce, including marriage subsequent to divorce. Medical malpractice, notice of claim, pardons for crimes. Personal injury actions, property, securities laws. Taxation, torts generally, wills and probate. All right, I hope I didn't say any of the banned keywords there. But you get the list. Oklahoma statute preventing recognition of adoptions by same-sex couples was unconstitutional because the full faith and credit clause required Oklahoma. Oh, Lord, same-sex couples. Okay, so that was 2007. And what else we got here? Ordinary principles of claim and issue preclusion do not apply to claims under international child. Okay. We'll have to read that on your own. Let's see. Even though a second state must acknowledge the right of a statutory successor to sue in its courts, the second state where assets of the insolvent corporation are located can apply its own laws to determine who will take such assets. Holding that it's John Hancock Mutual Life Insurance Company versus Yates in 1936, holding that the Georgia courts had to give full faith and credit to a New York parole evidence statute which prevented recovery on an insurance contract made in New York. Again, contracts, one of the things where this applies, the fact that the INS's test to determine a conviction's finality for immigration purposes did not construe a conviction, as the Maryland courts do, did not violate the full faith. Okay. So it did not bar the application of the no prejudice rule under New York common law to a claim of insured municipality from California for coverage under a pollution and remediation legal liability insurance policy that specified the application of New York law, since contractual choice of law clause had not been procured by fraud or overreaching. Although the notice prejudice rule applied in California, the court could not balance the interests of California against New York's interests. Wow. Pollution remediation legal liability insurance policy. That sounds special. All right, let's continue. Full faith and credit clause did not prevent Pennsylvania from enforcing legislation designed to regulate under ALIA the interest rate its residents had to pay on mail order installment sale contracts entered into between Pennsylvania residents and an Illinois corporation where there was no conflict between Illinois policy and Pennsylvania policy. Yikes. 1910, Olmsted versus Olmsted. Oh, here we go. The California Compassionate Use Act did not, under a full faith and credit clause, preclude a California defendant's arrest and prosecution for marijuana possession in Oregon. The CCUA, by its terms, provided nothing more than a defense against the enforcement of certain California marijuana laws. And Oregon did not and could not enforce California's marijuana laws against the defendant. Okay. California state courts properly refused to give full faith and credit to a Colorado document declaring that the petitioner had witnessed and witness had a common law marriage under Colorado law. The California courts properly applied Colorado law in considering all the relevant evidence of the couple's cohabitation and intent to hold themselves out as common law spouses. Say California properly applied. Let's see. This is a little bit confusing here. Oh, the Defense of Marriage Act, which permits states to refuse to give full faith and credit to same. Oh, that's why. All right, we'll move along. Holding that neither the full faith and credit clause nor any provision of the federal constitution require that New York apply Virginia and Maryland notice of claim provisions applicable to claims against entities of those states to claims brought against state universities of Virginia and Maryland based on their roles in the manufacture and sale of allegedly, contaminated human growth hormone. 2000. Wow, those are some pretty creepy cases. And the Franchise Tax Board of California versus Hyatt in 2016. In a Nevada taxpayer suit against the Franchise Tax Board of California related to allegedly abusive audit and investigation practices, the Nevada court applied a special and discriminatory rule, and thus violated the full faith and credit clause by awarding an amount which exceeded the maximum that could have been awarded in similar circumstances against the Nevada agencies. So they're out for wanting to get money from California. I kind of can understand why. But it didn't work because of the application of the full faith and credit clause. Now we're on to a very important section here, section 1023, when a federal question arises under full faith and credit clause. A question arising under the full faith and credit clause is a federal question. And the Supreme Court of the United States, now this isn't the United States Supreme Court, this is the Supreme Court of the United States, is the final arbiter for these, for both state and federal courts. When any question is raised as to what is a permissible limitation on such clause. However, in order to create a reviewable federal question under constitutional provision as to full faith and credit, the fact that the validity of the laws of another state is drawn into question by the courts of a state determining rights arising under such laws of such other state, and not merely the construction of such laws, must be shown. So that's in the validity, not just a construction. So it's not just saying they have the laws, or it has to be the validity, so that the laws are doing the right thing, not just construction, that they were done right. Stated another way, full faith and credit are not denied to a statute of another state, where a court does not deny its validity, but only construes it. The requirement of full faith and credit permits a court of one state to construe the statutes of another state when the court is called upon to give such statutes the sanction of its process. In this case, the approval. A mere error of construction in a candid effort to construe the laws of another state is not a denial of full faith and credit. To constitute a violation of the full faith and credit clause, it is not enough that a state court misconstrue the law of another state. Rather, the misconstruction must contradict the law of the other state that is clearly established and that has been brought into the court's attention. So again, misconstruction must contradict law. The full faith and credit clause does not require the courts of one state to follow the construction given by the courts of another state to its statutes, particularly where such construction would render the statute unconstitutional. On the other hand, in an action on a bond given pursuant to a foreign statute, see now again the full faith and credit clause affecting foreign statutes, that statute, as construed by the highest court of the state in which it was enacted, must be accorded the full faith and credit which is required by the federal Constitution in respect of the public acts of a sister state. And again, that's footnote 11 on that one. Graybar Electric versus New Amsterdam, 1944. Okay. So on here we have where a court construes a statute to place demands against an estate founded upon a judgment to refer only to domestic judgments. Such construction does not violate. Okay. Construes to place demands founded upon a judgment. Okay, there it is, founded upon a judgment. Such construction does not. Okay. Where only some rule of common law of England is involved in determining rights governed by the law of another state where the common law prevails, construction of the common law given by the courts of the foreign state will control. In preference to the construction given by the court of the state of the contract. So, rules of the state were litigate. Let's continue. We're moving on to section 1024. Operation and effect of full faith and credit clause. Generally, judgments. So now we're on to judgments. And let me just double check it on the chat here. Refresh it, make sure it's all keeping up with everyone. Indeed. And please hit the like if you're still here. And let's keep this moving. Full faith and credit clause, which has been described as a nationally unifying force, prescribes a rule by which courts, federal and state, are to be guided when a question arises in the progress of a pending suit as to the faith and credit to be given by the court to the public acts, records, and judicial proceedings of a state other than that in which the court is sitting. The full faith and credit clause applies to matters between states and to matters between a state and the federal government. The purpose of the full faith and credit clause is to preserve rights acquired or confirmed under public acts and judicial proceedings of one state. So it's to preserve the rights acquired or confirmed, made firm by confirming, under the public acts and judicial proceedings. That's how rights are acquired or confirmed. Requiring recognition of their validity in others, in other states. Accordingly, the full faith and credit clause demands that state court judgments be accorded full effect in other states and precludes states from adopting any policy of hostility to the public acts of other states. The full faith and credit clause requires each state to give effect to the official acts of other states, and a judgment entered in one state must be respected in another, provided that the first state had jurisdiction over the parties and the subject matter. However, the full faith and credit clause requires at most that a state give effect to rights established between parties that arise from judgments. So rights, at most, that a state give effect to rights established between parties that arise from judgments, agreements, or statutes originating in other states, and therefore is inapplicable to the enforcement of an out-of-state court's decision to issue a commission authorizing certain depositions and a demand for document production. Ooh, I love how they throw this in here. So we're citing a case, number 9. It's let's see here, how a full faith credit clause at most gives states effect to rights established between parties arrived judgments, right? And therefore is inapplicable. So at the very most, okay, I see how they're wording this. So it requires at the very most that a state give effect. These are the obligations. A state must give at the very most, has to give effect to the rights established between the parties that arise from the judgments, agreements, or statutes from the other states. So if that's the most it does, is inapplicable to the enforcement of an out-of-state court's decision to issue a commission authorizing certain depositions and a demand for document production. So in that case, let's look at it really quick. Footnote 9. And it's out-of-state subpoenas issued by New York Council for State of California Franchise Tax Board. Okay, so this council wants documents or something from the Tax Board of California, and they couldn't use the full faith and credit clause to do that. It's inapplicable. Additionally, the full faith and credit clause is not implicated where the issue decided by a court in another state is different from the issue being decided by another state's court. Footnote 10, People versus, this is 2017. So a lot coming out of New York there. All right, let's continue. And on our observation here, with respect to judgments, the full faith and credit obligation is exacting. With the judgments, it's exacting. That's footnote 11, 2016. Federal courts are bound equally with state courts to observe the command of the full faith and credit clause where it is applicable. Full faith and credit is required by the Constitution only with respect to those public acts which are within the legislative jurisdiction of the enacting state. Full faith and credit does not mean that the states must adopt the practices of other states regarding the time, manner, and mechanisms for enforcing judgments. Remember, the validity and judgments are about the best, but enforcing it, they don't have to have the practices. They'll use their own practices for enforcing, but they will enforce. The full faith and credit clause expresses a unifying principle looking toward the maximum enforcement in each state of the obligations or rights created or recognized by the statutes of sister states. The full faith and credit clause requires each state to recognize and give effect to valid judgments rendered by the courts of its sister states. Full faith and credit command is exacting with respect to a final judgment rendered by a court with adjudicatory authority over subject matter and persons governed by the judgment. Final judgment in one state, if rendered by a court with adjudicatory authority over the subject matter and persons governed by the judgment, qualifies for recognition throughout the land. Nice. That was 2018. Full faith and credit rule was extended to all courts, federal as well as state, 1938. The full faith and credit clause does not mean that the forum state must follow the rendering state's mechanisms for enforcing judgments, and that was 2019. Montana. All right, and that takes us on to section 1025. 1025. Attempts to evade applicability of full faith and credit clause. The full faith and credit clause, like other appropriate provisions of the federal Constitution, limits the power of a state to determine the confines of the jurisdiction of its courts and the character of the controversies which shall be heard therein. A state cannot escape its constitutional obligations under the clause by the simple device of denying jurisdictions to the courts otherwise competent. Also, a state may not, under the guise of merely affecting the remedy, deny enforcement of claims otherwise within the protection of the full faith and credit clause, where its courts have general jurisdiction of the subject matter and the parties. And that's footnote 3, 1936. This one here is Connecticut, 1935, American Law Review, 4735, so well established. And we're on to section 1026. And this is where we get on to the applicability of full faith and credit clause to territories and Indian nations. Now, in this section here, we're going to get on to U.S. Code. So, by virtue of Act of Congress 28 U.S.C.A. Section 1738, which gives force and effect to the full faith and credit clause, which acts in accordance with the mandates of Constitution Article 4, Section 1, the command of the clause is made applicable to the public acts, records, and judicial proceedings of territories, as well as states. Therefore, the full faith and credit clause is made applicable to territorial statutes with the same force and effect with which it applies to statutes of the various states. Thus, the full faith and credit clause applies to the District of Columbia. Think about that now. It's going to be reciprocal. That other states would consider it a sister state. For the full faith and credit purposes, Puerto Rico is a functional equivalent of a state. Lucky for them. 2006. There appears to be a difference of opinion as to whether an Indian tribe or nation is a territory whose laws are entitled to full faith and credit, with some authority holding full faith and credit applies and other authority holding to the contrary. So let's see. Applies is 5. Navajo tribe, 1975. In New Mexico, of course, because the Navajo Nation is a territory within the meaning of that statute. In New Mexico, because they give it that meaning. Interesting. And 5 was contrary, yeah. All right. 6. 1977, so right around the same time, full faith and credit does not require Arizona courts to give full faith and credit to enactment of the Navajo Tribal Council because the word territory was not intended to apply to Indian. Wow, so you get both ways, because New Mexico, in that jurisdiction, it's considered territory, but in the federal jurisdiction, it's not. We're on to the limited sovereign powers of states, section 1027. And let's check over the chat before we go any further. And refresh the chat. All right, looks like we got a little bit thin showing here, but we're going to continue anyways. This is a very important topic, so salute to you all that are still here. Some important exceptions contravene the letter of the constitutional provision as to full faith and credit and are permitted to do so, but only because they are deemed not to be within its spirit. Subject to the restraint and limitations of the federal constitution, the states have all the sovereign powers of independent nations. These limitations were imposed for the accomplishment of certain purposes and in order to preserve the harmony in the constitutional system. The limitations upon the powers of the state are themselves limited to a certain extent, or rather, certain things are deemed not to be within them. Local sovereignty over local questions and the requirement that each state give full faith and credit to the public acts, records, and judicial proceedings of every other state seem to have had for their purpose not the attainment of uniformity in laws, but rather the right of each state to have local and peculiar laws which all others should respect and enforce within certain limitations, and to enable it to make and enforce such laws as it desires. Each state is permitted to retain such limited sovereign power. Now that's well written there, I would say. That probably captures the gist of it right there. No reason to reread it. You guys can too. This is a great paragraph here, starting here. And this is all from 3 and 4 footnotes. Alaska Packers Association, okay, and the Pacific Employers Insurance Company. Oh gosh, so these are probably real dry cases, 1912, 1935. However, some great narrative comes out of them. There is no exception to the full faith and credit statute that would allow landowners who have been required to litigate unripe takings claims in state court to avoid the preclusive effect of a final judgment of that state court by reserving the right to advance federal takings claims that are not ripe until the entry of a final state judgment denying just compensation. Jeez. And that's San Remo Hotel versus City Council of San Francisco, California. And that takes us on to section 1028, the applicability of exceptions to specific statutory provisions or public acts. That some questions have arisen as to what types of statutes or actions are subject to the full faith and credit clause. Actions or determinations of a state's governor that he or she has jurisdiction to grant asylum to fugitives are not entitled to full faith and credit. The acts of certain state commissions are not entitled to full faith and credit. We read about that earlier. So this was state of Alabama, 1996, and this is Minnesota in 95. Very interesting here. They're all around the same time there on this one, on the applicability of exceptions to specific statutory provisions or public acts. So interesting there. Although it requires recognizing and honoring foreign judgments, full faith and credit clause does not compel the foreign state to use the period of limitation of a foreign state. Statutes of limitations and saving statutes are not sufficiently substantive to require that full faith and credit be applicable to them. Okay, so statutes of limitation will be in the foreign state. The full faith and credit clause has nothing to do with the conduct of individuals or corporations and has no application to the laws of a foreign country. The full faith and credit clause does not reach the question of what effect federal entities must give to state pardons. The full faith and credit clause does not require that sister states enforce a foreign penal judgment. The full faith and credit clause does not require the one state to substitute its weapons statutes for those of another state with regard to the prosecution of an agent of another state's bail bondsman or bail or bondswoman for unlawfully carrying a weapon. While in the state to arrest a fugitive, the forum state is not required to give the full faith. Oh gosh, private investigator's license. Jeez, the full system of rules that a state court adopts to govern admission to the bar as a matter of local policy and assessments made by the courts of other states regarding the petitioner's legal training need not be extended. Full faith and credit. Notice they use legal training, not law. Constitution does not require that full faith and credit be given to a defendant's driver's license issued by another state. Okay, in possession of that driver's license does not entitle the defendant to drive upon another state's highway when the defendant's driving privilege has been revoked in the other state. Okay, credit be given to a driver license, not the driver. I see. Okay. Full faith credit clause of the United States Constitution does not apply to judgments of foreign countries. Applies to sister states. Does not preclude a state from determining under its own laws whether a guilty plea in another jurisdiction constitutes a prior conviction for purposes of its habitual criminal statute. Wow. Well, that makes sense. And the question of whether a statute of one state, which in some aspects may be called penal, is a penal law in the international sense, so that it cannot be enforced in the courts of another state until the full faith and credit clause under the full faith and credit clause depends upon the question whether its purpose is to punish an offense against the public justice of the state or to afford a private remedy to a person injured by the wrongful act. In making this determination, a court should also consider whether the wrong to be discouraged by the statute is a wrong to the public or a wrong to the individual. Petition for discretionary review refused. Let's see. Retesting out-of-state attorneys did not violate the full faith and credit clause since no act record of judicial proceedings had passed the bar. Okay, so attorney in practice did not violate. So yeah, they want to milk them, and with good reason. Okay. We're on to section 1029, public policy of forum state as affecting full faith and credit requirement generally. Violation or conflict with forum state public policy. As a general principle, local policy may not override the constitutional requirement of full faith and credit. Thus, a valid judgment rendered in one state will be recognized and enforced by a sister state, even though the strong public policy of the latter state would have precluded recovery in its courts on the original claim. Still, there is some room of play of conflicting state policies in the effect and operation of the full faith and credit clause, although such room is narrow. It has thus been recognized as the most significant exception to the full faith and credit clause that there are some limitations upon the extent to which a state will be required by that clause to enforce the judgments or acts of another state in contravention of its own statutes or policy. Therefore, the full faith and credit clause does not ordinarily require a state, with respect to persons and events within its borders, to substitute for its own law the conflicting law of another state, even though the latter law is of controlling force in the courts of the latter state with respect to the same persons and events. Although the full faith and credit clause ought not lightly to be set aside. So, I think we can follow here that the full faith and credit clause may not apply, but it's not lightly set aside. Under the full faith and credit clause, a state need not substitute statutes of other states for its own statute dealing with the subject matter concerning which it is competent to legislate, especially in cases where application of the clause would create an impasse which would leave a litigant remediless. Full faith and credit principles allow each state to enforce its own statutory policy, so it's in a positive way. However, a state may not refuse to enforce a judgment of a foreign state on the ground that it would result in a violation of the public policy of the forum state. So public as opposed to private judgment there. Nice. Where the policy of one state statute comes into conflict with that of another, the necessity of some accommodation of the conflicting interests of the two states is even more apparent than a case of enforcement of the foreign judgments. A rigid and literal enforcement of the clause, without regard to the statutes of the forum, would lead to the absurd result that, whenever a conflict arises, the statute of each state must be enforced in the courts of another, but cannot be enforced in its own courts, unless by force of that clause a greater effect is thus to be given to a state abroad than the clause permits it to have at home. It is unavoidable that the Supreme Court must determine for itself the extent to which a statute of one state may qualify or deny the rights asserted under the statute of another. Hence, the full faith and credit clause does not require the enforcement of every right conferred by a statute of another state. Nothing in the federal Constitution ensures unlimited extraterritorial recognition of all statutes or of any statute under all circumstances. Good language here again. So here's the more negative side of the full faith and credit clause as opposed to the positive one we saw in the earlier section. If in the application local policy must at times be required to give way, such is part of the price of our federal system. A court may be guided by the foreign state public policy and determine the law applicable to a controversy. Full faith by policy, right? Full faith and credit clause is not inexorable and unqualified command, but leaves some scope for state control within its borders of affairs which are peculiarly its own. I still didn't get that right, but you get it. All right, it's getting late here. I'm getting a little tongue-tied, and I think we're kind of the end of this section here. Here's the other one I wanted to read. Constitutional requirement of full faith and credit does not automatically compel a foreign state to subordinate its own statutory policy to a conflicting public act of another state. Rather, it is for the Supreme Court to choose in which case between the competing public policies involved. All right. And we get into section 1030, determination as to which state's public policy prevails. And I think we're going to be saving this for the next one because after this we get to particular statutes and judgments. So a lot of this is going to get more into the, let's just finish it up because this is the end of the entire section of jurisprudence of constitutional law. So let's just get through this here. Prima facie, every state is entitled to enforce its own courts and its own statutes lawfully enacted, and one who challenges a state's right to do so because of the force given to a conflicting statute of another state by the full faith and credit clause assumes the burden of showing upon some rational basis that of the conflicting interests involved, those of the foreign state are superior to those of the forum. That's a high bar. Remember, that's a rational basis. It follows then that not every statute of another state will override a conflicting statute of the forum by virtue of the full faith and credit clause. That the statute of a state may sometimes override the conflicting statute of another, both at home and abroad, and again, that the two conflicting statutes may each prevail over each other at home, though given no extraterritorial effect in the state of the other. The test or controlling principle, that is the interest of the forum and the other state, must be weighed and balanced. So what's our controlling principle or test? If there exists in the state of a forum a statute or public policy and the governmental interest of that state in the persons, property, or events in the state involved in the litigation outweighs the governmental interest of the foreign state for whose statute recognition sought, the refusal of the courts of the forum to give effect to the right under the foreign statute does not constitute a denial of full faith and credit statute. So, again, we're looking at the principles here. It's not just about imposing another statute without reason because you say that the full faith and credit clause applies. It has to have a substantial valid purpose. The controlling principle or test is that. Okay. On the other hand, if the governmental interest of the state of the forum in the subject of the litigation is lacking or slight as compared with the governmental interest of the state whose statute recognition is sought, the refusal of the courts of the forum to accord that recognition is a denial of the full faith and credit. Where the governmental interests of the two jurisdictions are equally balanced, and the statute of each properly extends over the event or transaction because of the connection with that state of one or more of the elements of the event or transaction, the forum may give effect to its own statute, although in conflict with the statute of another state in which some of the elements of the transaction are located. And the latter state may in turn do likewise if the action is brought in its courts. In determining whether the statute of the state under which foreign rights arose or the law of the forum should control in matters involving policy and conflicting interest, the rule is fairly well settled that different considerations usually apply where the statute creating a foreign right, which it is claimed should be given effect, is set up by way of defense to an asserted liability from those where merely affirmative rights are claimed under a foreign statute. Upon several occasions, the Supreme Court has held under the full faith and credit clause, one state cannot refuse to give effect to a substantive defense arising under the applicable statutes of another state if failure to sanction the defense thus created by the statute of such other state's subjects the defendant to irremediable liability. The Supreme Court has pointed out, however, that the necessity of balancing the interest of the forum and of the foreign state, the statute of which is to be asserted to control, and not any the less whether the statute and the policy of the forum are set up as a defense to a suit brought under a foreign statute, or a foreign statute is set up as a defense to a suit or proceeding under local statute. In either case, a conflict is the same in each. Rights claimed under one statute prevail only by denying effect to the other. In both, the conflict is to be resolved not by giving automatic effect to the full faith and credit clause, compelling courts of each state to subordinate its statutes to those of the other, but by appraising the governmental interests of each jurisdiction and turning the scale of decision according to their weight. Beautiful words here. And all these relate to evidence too, right? Keeping out bad evidence, keeping in good evidence, weighing the evidence, not just the amount of evidence, but the credibility is the weight. Let's continue. I think these are us restating what we read, and yes, indeed. And we get section 1031. The application of public policy exception to full faith and credit clause to particular statutes and judgments. So the full faith and credit clause does not require a state to apply a second state sovereign immunity statutes where such application would violate the first state's own legitimate public policy. However, there are no considerations of local policy or law which could be rightly deemed to impair the force and effect which the full faith and credit clause and the Act of Congress, 28 U.S.C.A. 1738, required to be given a money judgment outside of the state of its rendition. The full faith and credit clause of the United States Constitution does not require a state to subordinate its own workers' compensation policies to those of another state. Even if one state's order indicated an intention to enjoin actions against an insolvent risk retention group's insureds, the order was not entitled to the full faith and credit or comity, and thus a stay in a nursing home's residence negligence action in another state against the insured nursing home was not warranted. Risk retention groups were not required to contribute to a guarantee fund in case of their insolvency in enforcing the stay of potentially indefinite duration, which would undermine the other state's important public policy of protecting victims of negligence in nursing homes and allowing them economic redress. Applying one state's tort claims notice provision. Boy, let me read that again. Applying one state's Tort Claims Act's claims notice provision in negligence action against the state university by the other state's employee, who is allegedly injured when loading a container owned by the university onto a vessel in the other state, would not conflict with or violate the other state's public policy, as would support determination that the state act was entitled to full faith and credit in the employee's action, even though the other state was competent to legislate on the subject matter of personal injury within the state and had sufficient contacts to apply its substantive law. Both states' acts had similar claims notice provisions, served similar purposes, functioned similarly, and applied to the public universities. That's 5, Oregon, California. Review denied. Okay. And there it is. Well, thank you so much for being here. That takes us to the end of this presentation of American jurisprudence and the provision for full faith and credit. So let's check here on the chat one last time before we head out. I appreciate you all for being here. For those of you that were able to stick it through to the end, I think we came upon some pretty good ways of looking at the provisions of full faith and credit from many angles, and where really the rubber meets the road, so to speak, when it talks about judgments, acts, statutes, and events that cross borders between not just states but countries, because states are considered sovereign entities, but then there are also certain obligations to maintain the harmony of the union, and that's what makes the United States of America such a great place. Audit them in the house. Appreciate you all for coming. Please hit the like on your way out, and I hope to see you all on the next one. Peace out.